Just going to start the recording. Okay, there you go. So welcome Adam, Ash, Dakota, Jess, Leonie, Monique, and Peter. So thanks for joining tonight's session. We're going to begin tonight's tutorial by having a go at the Happiness for Learning mini workshop. And this time I'll be focusing on journaling. In the previous two sessions, when we first began the Happiness for Learning mini workshop, we had began this series of workshops on the understanding that people who are happy generally perform better, don't they? We probably see this happening in our lives, and it seems to be very intuitive that somebody who's happy is actually able to do more. And so somebody who's happy, a student, for example, who's happy, is likely to be in a better position to learn. So we're trying to equate the mini workshops we're doing with your ability to be a better student and to get things done and be able to successfully complete this unit. And that's the reason why we have this Happiness for Learning mini workshops. And we also stated that when you speak about happiness, we're talking of happiness from a more general point of view, such as about feeling happy, but we're looking at it as a set of positive emotions, which could be about joy, happiness, curiosity, and so on. It could be about having that sense of pleasure. And so that was the first session that we had. And in the second session, we talked about the importance of gratitude in happiness. So when a person gets a sense that there are many things that person should be thankful for in life, that person tends to be quite happy. But it's not just a question of good things happening in one's life. It's also about paying attention to the good things. And so Professor Paul Dolan, who's a foremost expert on happiness, says that there is kind of an economic side to the idea of happiness, and that's the reason why we use the concept of pay attention to. So the things that you pay attention to are the ones that actually become dominant in one's life. And so, for example, the thrill and the excitement of getting a new job, of getting a pay raise, or probably even entering into a relationship subsides after a while because people adapt. People then take for granted the good things that have happened in the past. And for this reason, the things that brought happiness to us before, things that would have made us grateful, no longer, after a while pale in terms of value. And which is the reason why when we looked at the second workshop, we talked about having to pay attention to things that we should be grateful for. So even if they've happened in the past, if we just bring our attention back to things that made us happy, or as important, if we begin to focus on things that can make us happy today, or things that can make us happy in the future, such as perhaps because the Christmas season is approaching, and we're going to be meeting loved ones, we will have an opportunity to relax and perhaps receive gifts. So if we pay attention and turn our attention to these things that can make us happy, then chances are we will be happy, because on their own, these external events, or even the internal events in our lives, if we do not pay attention to them, they probably are unlikely to give happiness to us. So that's the whole point of the second session on happiness. Now this time, we will focus on the idea about journaling. The idea being, and so if we after this session, we will critically reflect on journaling and its benefits and how to engage in journaling. So journaling essentially means putting on paper, or probably writing on a computer, your thoughts, whether they're thoughts that make you happy or the thoughts that make you concerned. And the idea being that there's only so much that can be retained in your mind. So for example, if we talk about problems, there are limits to our ability to examine problems if they're just all in our minds. And the researchers would suggest that if you put things on paper or begin to analyze things by putting your words on a computer, probably drawing mind maps and so on, you're actually in a better position to understand what's going on. And one way of looking at this is that even by the action of writing things on paper, there is the advantage of putting distance between yourself and the problem. And in the process of putting distance between yourself and the problem, you're probably able to gain a better perspective of how badly or how bad or how good things are. So we're going to talk about journaling briefly in a short while. So in terms of benefits of journaling, journaling helps you clarify your thoughts and feelings. They actually help you know yourself better. They also reduce stress. They solve problems more effectively. And they actually help resolve disagreements with others. So journaling is just that activity of having a journal, whether it's a notebook that you have, an ordinary piece of paper, or probably writing stuff on the computer. So let me just ask you a question first. Have you ever engaged in journaling? Have you? Can you just, if you could, can you type an answer in the chat box if you have? Never, from Monique. Okay. Only for Torts B. Okay. So in Torts B, there was an activity where you were asked to kind of create a journal of maybe the learning process, things, your experiences in the unit. Very good. Peter says that several courses have reflective blogs, and there is a learning diary. Okay. Were these acts of having reflective blogs or learning diaries helpful to you? Were they helpful? So as a follow-up question, for those who've provided an answer, were they helpful? No. Okay. Okay, some found it helpful. Okay.
I think Peter Anthony, at the time you think, oh yeah, why am I doing this? It's funny that we started off and I don't even know what unit it was. We had to do a reflective blog, and it carried on to different things like torts and other units.
Yes.
I find that I'm doing them now for me.
Yes.
So whether, like you're saying, most students will say, oh, it's a waste of time, this, that, and the other. But I look back on them and I think there's a lot of value. So that's just me.
Very good. So the research tells us that there is great value in journaling, not only because, as we said, there's only so much ideas, thoughts, and feelings you can retain in your mind. And putting it on paper allows you to analyze what you've written. And, as you go through it, it makes sense. You can tell yourself whether you should be putting as much importance as you should on certain things that make you anxious. It allows you to analyze what you've written on paper. So it gives you distance. And what I have found, because I maintain an online diary on Manjo, I've had it for the past 3 years, is that historically, when I go back to what happened a year before, even 2 years ago, I'm actually able to determine if, something positive has happened in my life. I can look back and say, oh, my life now is much, much better than before. I'd say that when I was struggling with this problem 2 years ago, it was like my world would end, and look at where I'm now. And sometimes there were times when I would write a journal to myself and addressing it to my future self. And I'd say, you're doing this as a way of talking to your future self. Because for some of us, it's sometimes we kind of do things in the here and now without thinking that the things we do today actually have an impact on who we are in the future. And it's difficult for us to imagine that future self, but there is a future self. A future self 5 years from now, in terms of you guys, could be about you becoming a lawyer. But a future self could also be 20 years down the road when we could be much older and be more frail. And it lets us determine, should we invest more time today in terms of becoming healthy, becoming more fit? And so there are many benefits of journaling, therefore. So having this said that, the researchers suggest that we should try to block off at a minimum 3 to 5 minutes every day to write and journal about things that are going well and things that are not, because there is value to putting things on paper. It's probably like, you know, writing an essay. It's one thing for you to just retain your ideas in the mind, and it's totally different when you begin to write that essay, and things just become clearer when you start writing stuff. The other important thing is that you should freely write about your thoughts and feelings relating to 3 things that are going well. So, you know, write as much as you can. Don't worry about grammar. And do not be judgmental about yourself or about what you write, whether in terms of how you write or what you write about. And try to develop this as a habit by journaling for the next 20 days. There's no reason why, you know, have to do it every day for, you know, for 1 year. But during that time when you feel like you're trying to develop that habit of journaling, it will be a good idea to stick to a routine of trying to spend time. Well, what's 3 to 5 minutes in a day, right? But if you keep on doing it, after a while, it just becomes so second nature to you. Okay, so I'll end it there, and that's the end of our mini session on journaling. And then we will proceed to our tutorial on unauthorized decision making. But before we do that, as I said, we will devote the first 10 minutes prior to the start of the tutorial to a drop-in session. So in this session, you can ask questions about administrative law as a topic, as a theme, and then you can also ask questions about the unit, whether it's assessments, you know, things like that. And then during the tutorial, I would also try to devote time, some time in terms of how to write a case note. But for now, let's talk about, you know, we're now having a drop-in session. You can ask any question you like. From Faraz, I like the concept of future self. Yeah, let me just go back to that point, because I may have mentioned to you that there was a time when life was extremely bad, about more than 2 years ago. I was clinically depressed. That was a terrible time. And it was a good thing that I was able to meet somebody who happens to be a senior lecturer at the School of Business and Law in one of the school retreats. And he happens to be a psychologist. And he'd tell me, you know, you need to do this. You need to do this for your future self. And I like that idea about doing something for my future self, as opposed to who I am today. Because at that time, the person I looked at, you know, as myself was somebody who was kind of broken. But the idea that, you know, there was a future self who was probably going to be happy, you know, that just inspired me. So, hang on, am I quiet? What does it mean?
Hey, Manjo. Manuel, can you hear me?
I could.
Yeah, thanks for the insight. I just had a quick question on the case notes that we're making.
Yes, go ahead.
The two-part, first of all, might have skipped my mind, but for the presentation that we do, we can pick anyone that, any of the 3 cases that we want.
That's right.
Okay, thank you. And when are they due? Are they due on the week 9?
Yep. So if you're doing a pre-recorded presentation of one of the case notes, they're due on the same date that the 3 case notes are due, which is in week 9. I can't remember the exact date, but it's in the unit profile.
Yep. Thanks, Manuel. Just clarifying that. And the happiness session is very useful to me. Thank you.
Very good. Very good.
Just struggling with, you know, all of life's ins and out, like working full-time, kids, and at the same time trying to, you know, keep up with the education side of things, which is broadening the horizon of the mind. So
that's right. Very good. So some of you seem to be experiencing a problem in the sense that the sound isn't coming across too well. The volume, in other words.
No, you're like clear now, but before it was like super quiet and I could barely hear you. So I don't know what's happening.
I didn't do anything.
It's just me.
I haven't really adjusted anything, so I don't know. Yes.
Stupid.
Yeah. No. I think sometimes, you know, it could be the problem with the internet. It could be the problem with Zoom as well. I've had that experience when a lot of people might be using Zoom, not just us, but worldwide. It can cause a problem with the performance of Zoom. But thanks for bringing that to my attention, because then I'll try to speak louder. Okay, other questions?
With the assessments, Manuel.
Sorry, Peter. Can I just interrupt, because Faraz was, in terms of pronouncing my name, it's Manjo. like Joseph. Sorry about that. I felt like it'll be better, if you pronounce my name right, because otherwise, that name gets passed on to other students, and people become confused. It's Manjo, like Joseph. Okay.
Yeah, thank you, Manjo.
Okay.
I'll keep that in mind. Thank you very much.
Okay, go on, Peter. Sorry for disturbing you. Go on.
That's okay, Manjo. With the assessments, if we're doing a video presentation, we don't have to let you know which case it is until the time?
No, you don't.
Okay, thank you.
Yeah. But as I said, in response to this question earlier, it has to be one of 3 cases. Okay. Okay. Other questions? So you could ask any question about administrative law or to discuss.
Sorry, Manjo, just as an offshoot of that, if we're in a group, it's only one in the group that needs to do the video presentation, isn't it?
That's correct. That's correct.
Yeah. Okay, thanks.
Yeah, but what needs to be remembered is that even though there is only one person who actually does the pre-recorded presentation, if you're working as part of a group, there are a lot of things that the other group members can do. They can help write up a script. They can help, if need be, come up with a better visual aid. They can help do better research so that what gets presented, sounds really good and focus on the key points and so on. So there's a lot of background help that can happen. So it's like if you see a movie, it's not just like you don't have a movie simply because you've got an actor like Brad Pitt performing. The director's there, the other people, whoever they may be, the people doing the costumes and so on. Yeah, so we look at it that way.
Manjo, it's Lois. I just have a question about the visual aids. I'm not quite sure, like what you mean. Like when you're presenting a case note, I'm not quite sure how visual I can make that.
Yeah, the visual aid can be as simple as what we're seeing now, which is a PowerPoint, a set of PowerPoint slides. So, for example, let's begin with the idea that you have a title page. So that the first slide of yours will probably refer to the case title. So what needs to be remembered is that the readers or the listeners oftentimes have a limited capability or capacity to remember everything that is said. I mean, at least it happens to me a lot. You tell me something, I'll be lucky if I remember 80% of what you say. So the visuals help us, help flag for us what will be discussed. At least the case title is there. The second part of the visual, we'll probably talk about the key points of the case. So it could be about the facts. So what is important is that as far as the statements about the facts are concerned, they have to be key points. They shouldn't be written as full statements. They should just be phrases highlighting the key points. So it could be like somebody got mugged. And then he reported to the police. The telegraphic idea. So then we don't really have to read the whole thing, because if there's so much information on a slide, it's very distracting. People, based on studies, cannot listen well and at the same time engage deeply with what they have to read. They can't do that. So it should be, telegraphic points. So if you will notice, when I talk about benefits of journaling, they're just know yourself better, reduce stress, solve problems more effectively, resolve disagreements with others. Those are key points. And you remember them. Now imagine if what is there is actually a script, in the sense that, what I'm saying to you now, we're actually in the form of a script, which I actually read out. That would be very distracting. So those are just key points that you're trying to telegraph or pass across to your audience. So I've already cited that as far as the visual aids are concerned, one, the title would be important. So we know what case it is. It can be about the facts. It can be about the issue. There could also be a visual aid in terms of the decision and then the ratio. It can also be about the importance. So those would be what, 5 actually 6 PowerPoint slides you should be making. The title slide, you can also begin with an objective. This is or the kind of an outline of what you hope to discuss or to cover. Then, so the third one would be the facts, just the key points. And then you talk about the legal issue. You talk about the decision, the key legal principles, and 6, the importance. But again, core concepts, not full sentences. And so therefore, compare and contrast what would have happened if I had a tutorial and in the course of the tutorial, I did not have any visual presentation. Can you see the difference?
Yeah. I just meant like.
Yeah.
Does it have to be PowerPoint or like what's some other?
Oh,
I was just trying to brainstorm other ideas because I just figured that most people will go for a PowerPoint, or is that more specifically what you're looking for?
The PowerPoint slides are more than sufficient. There are other softwares, I think, like what are they? I mean, I've seen Scott Beatty use other forms of softwares. I'm not familiar with them, which kind of are animated and so on. I don't remember what they are. But as far as I'm concerned, the PowerPoint slides are more than sufficient. And so, yeah.
Okay, no worries, thanks.
Okay, so I'm gonna bring up the screen again, because otherwise, what we're gonna have is just, on the screen, a name, and everything is just blank. And so I think people are more attracted to listening to somebody when not only are their ears or their minds engaged, but there's something visual there. And we will probably remember that the trite saying that a picture, how do you say that? Picture is worth 1,000 words. Is that correct?
Yes.
Yeah.
Manjo, can I ask you a question?
Go ahead. Yep.
With our pre-recorded submissions,
yes.
What format do you want that in, and how can we submit it?
Oh, okay. Number one, let's talk about way to submit it. Moodle. It will be submitted on Moodle. So I have yet to decide whether or not it can be submitted as a file or potentially as a link, an online link, and meaning you store it somewhere. So I have to check with DASAC on that as to what can be done. Now, in relation to the format, is that MP4 that will need to be used for videos? I'm not sure, but it has to be a video.
Yeah, see, I'm not sure. If we wanted to do the recording on Zoom, where do we submit it into so that you can watch it?
No, that's what I meant. So if you were recording a presentation, you will be using some software. I'm not sure which one it will be. You could probably do a recording on Zoom or some other software. I'm not sure. Now, after you've done the recording, it will be saved in a particular file, which I imagine is an MP4, I think. Now, once you have that MP4, the question now is, where do you submit it? I would imagine you will be submitting it to me in Moodle when I create the link, or as an option, I might ask you to submit that that file in YouTube, which can be. Hang on, I'll go back to you, Lois, in a short while. So the most likely thing that will happen is that I will create a closed page on YouTube, and you save your file there, and then you give me the link. That way, everyone in our unit can actually have a chance to have a look at what everybody else has submitted. Yes, Lois.
Manjo, I was just going to say, we've had to do video presentations for other subjects in Contracts B and in tort. Yes. And the way they were both submitted was we had to do the recording. We could use anything to do the recording. We did, I think some people use Zoom, people use cameras, people even use their phones to do the video recording. And then what they had to do was upload it to YouTube, but not post it. So the only people who could access it was people you gave the link to. I mean, I don't know if everyone's done that, but it seemed to work well for Anna and for Amanda Stoker when I did contracts and admin, contracts and torts.
Okay.
So then we posted the link into a document, which then got submitted into Moodle. So then you had the link.
Yeah, we did that in contracts. We did it on YouTube and then posted it so it wasn't public, it was private.
No, yeah, it's private in the sense that everyone in our unit can see it. I mean, are there any concerns about privacy if everyone in our unit is able to see a recording on YouTube? Or that's not necessarily a problem?
No.
Okay,
I'm not sure how, if I wanted to do it on Zoom, how would you go about posting it on YouTube? I'm not sure how you do that.
At the end of the day, when you do a recording, you're going to end up with a file. Yes. If you record it on Zoom, for example, it saves it as a file, which is kind of an MP4. So with the file that you've saved, it's then a matter of uploading it on YouTube. Okay. Now, I'm going to get into the details of that later on. So, because I don't want to spend too much time on the technical aspect, it's something which we should be able to quickly resolve by coming up with guidelines. Okay, so what I'd like to do now, we can just go back to a drop-in session after we're done with the tutorial. So I'd like to focus this time on the topic this week, which is on unauthorized decision-making. I'm just going to address the question earlier raised by Monique as to the date of the final paper. I haven't made a decision on that. I'm just trying to get final approval from the School of Business and Law or from the Learning and Teaching Services, because I had to log in a request to modify the unit profile so that instead of it indicating that we will have an examination for the final assessment, it will just be a final take-home paper. And until I am able to do that, I can't give you the date because I think I need to reflect on the unit profile, the suggested date. So I'm just securing the information there, but I think I should be able to get the approval by next week. So just hang on there. I should know by next week as to when the release date of the final take-home paper will be. Okay, so let's talk about unauthorized decision-making. So again, this is important because, as we said, administrative law essentially focuses on decisions made by administrative decision makers that have an effect on individuals or corporations. So individuals in the sense that a person is directly affected as opposed to people in general. So we make the distinction because, as we've probably covered before, a law has an effect on everyone, as opposed to a decision by an administrative decision maker that affects a person in particular. And so in relation, therefore, to the decision making made by an administrative decision maker, that raises the question of whether or not the process of making the decision or whether or not the decision itself was actually authorized. And we wish to know when are the instances when a decision needs to be authorized, and if so, by what? And what actually happens if a decision is unauthorized? And what exactly are the grounds for us to say that a decision is unauthorized and therefore subject, for example, to an application for judicial review? And in this particular tutorial, we will also examine the question of what happens when a decision is made by an administrative decision maker on the basis, for example, of subordinate legislation. In other words, regulations or bylaws or guidelines that are drafted, created, passed, or issued by an administrative decision maker on the basis of an empowering legislation. So in other words, there is a primary legislation passed by the Commonwealth Parliament, for example, which authorizes an administrative decision maker to create subordinate legislation in the form of bylaws, regulations, guidelines, and so on. And in that scenario, would it be permissible, for example, or what happens when the subordinate legislation might be contrary to the primary legislation? So we're going to be examining these types of questions. So in terms of key outcomes tonight, and I'd like to flag as well the point that what we have done, starting I think in the tutorial last time, was that we will also have a tutorial question that we'll end up discussing the key concepts that are of relevance in terms of answering the weekly quiz. So if some of you have had a chance to actually have a look at quiz 4, which pertains to the week 5 topic, then I'd like you to know that we will be taking up the concepts that are applicable in terms of helping you understand and answer the quiz, quiz 4. Okay, so in terms of key outcomes, after studying this topic, you should be able to discuss and explain whether legal authority is required for every executive decision or action to be made. And you should be able to discuss and explain an authorized decision making and the types of executive decisions and actions that do not require specific legal authority. You're welcome, Monique. Actually, I'm happier that students, at least for the last quiz, did much better than in the past. So, I mean, in the previous 2 quizzes, where I think the passing rate was about 30%. This time was about 75%. So which is good. And if you could maintain that, then it will mean that there'll be more students who will end up completing the unit and getting better grades. And I think it's also good for, should I say good for the soul, but I mean good for the morale to know that you seem to be doing it well instead of struggling, what actually happened there. Okay, very good. Now, so before we continue, do you happen to have any questions or comments? And I am reminded that I was getting feedback that I tend to speak too fast, that I tend to move the tutorial too quickly. So I will make it a point to remind myself of these observations and slow myself down in terms of the pace by which I speak and also the pace by which I end up discussing concepts. So if you see me slowing down, it is in response to the observation and comments I've been getting. Okay. Discussion question 1. I'm just going to read this. It's a short question anyway. So, judicial review is said to be of limited scope that focuses on the process of decision making, observance of fairness, procedural fairness, and natural justice, etc., and not on the decision itself. In what circumstances is judicial review said to involve a review of the decision itself? Let me provide a background just to clarify this important point, because a better understanding of judicial review will be crucial as far as the final assessment is concerned. So what we need to remember is that judicial review is not meant to involve a review of the merits of a decision. So when we speak of the merits of a decision, for example, it could be about the correctness of the decision, meaning is the decision correct according to the facts? So in other words, what happens when a decision maker incorrectly, makes a decision that seems to be incorrect in the sense that he wrongly evaluated evidence? Can that be the subject of judicial review? So that would go to merits. Or it could be a question of when a decision maker applied policy or when a decision maker used discretion. Can those be the subject of judicial review? And the answer, and I see Peter shaking her head, the answer is no. Very, very good. Now, I need to tell you that somehow on my screen, I'm only able to see 5 students at the same time. It's a limitation of Zoom. I can't see everyone. So it's possible that there are more of you shaking your heads or nodding your heads, but I'm not able to see you. And that seems to be a limitation of Zoom. But at the moment, the ones who are appearing on my screen are Monique, Pita, Lois, Leonie, and I don't have her name. Okay, so let's just go through this. Do you have an idea as to when it might be said that judicial review, in a sense, involves a review of the decision itself? Do you want to give it a try?
And Manjo,
yes.
When the it is so totally unreasonable as to be contrary to law.
Very good. So one of the instances, thank you, Peter. Very good. I mean, how do you know that? Very good, Peter. It means, you know, you've developed a very good understanding of what's LMAO, L-M-A-O, L-M-A-O. What does it mean? Oh, laughing my ass off. Okay, very good. Okay, yeah. So I'm not familiar with some of these acronyms. So that's good. Yeah, so we will later on see, and I think we're going to be covering it actually today, the issue about reasonableness. So the idea that a decision is so unreasonable that no reasonable person or no reasonable decision maker would actually arrive at a decision, in a sense, involves an examination of the decision itself, doesn't it? That would, in a sense, examine, you know, the decision itself. So this is an instance when when a decision seems to be so unreasonable, or would amount to what is known as Westbury unreasonable, that in that sense would involve, in a sense, a review of the decision itself. And in one or two of the tutorial questions that we have today, we will notice that what the judges have done, or in the cases that I will be citing, is actually to examine the reasonableness of the decision. Although we will take up Westbury and reasonableness more, I think, in week 8. So very good. Thank you. So let's, there will be 5, actually 6, but I think 6 is, question 6 will be covered by question 2. So we will just focus on question 2. Is it question 2? Yeah, I think so. Okay. Can I ask somebody to read question 2 for us?
I will.
Amanda, yeah.
Yeah. The Minister of Health created a health awareness program that provided a budget of $20 million for a program to promote awareness of men's depression as a health issue. Red Manson asserts that the program is rubbish, and he has called on the minister to withdraw the funding, claiming that the money is better spent on other programs in the current economic environment. He also asserts that the minister has no legal authority to make the budgetary decision. When the minister refused to revoke his decision, Manson considered filing an application for judicial review on the ground that the decision is unauthorised. He has come to you as a solicitor. What would you advise him?
Thank you. So let's have a think about that for a few seconds. Now, before we start answering the question, what do you suppose are the legal issues? In terms of giving advice, you need to be able to identify the legal issues, which potentially can make the decision unauthorized, or potentially goes to the question of whether or not an application for judicial review can be made. So at the very, at its core, the first question you need to ask is it appropriate to apply for judicial review? That's the basic question. And that leads us to, as we examine that question, it brings us to the question of, would there actually be a ground for judicial review, particularly in the sense that whether or not this decision is unauthorized. So what do you suppose would be the legal issues here? And then we will start answering, providing the rules or the legal principles that inform on those legal issues.
Manjo, I'm sort of asking myself when I read this, and I might be completely off track, but is it even an administrative decision that affects Manson?
Okay, go on. And what's the crucial point about what you're saying?
Does he have any standing?
Ah, very good. So, does Manson have legal standing? Very good. Now, this specific question, Monique, is actually related to a broader question. And that broader question is really about talking about when is judicial review available? I mean, or what are the requirements for someone to be able to apply for judicial review? Okay, so maybe the focus there is this. What are the requirements for someone to apply for judicial review? Do we remember what they are? Go on.
It must be justable.
So there's the issue about justiciability. Okay. So is it a matter that is appropriate for the courts to determine or examine? Okay. What else? So before we can have judicial review, before you can apply for judicial review, what are the questions that we need to answer? Anything else?
Is it a decision of administrative character?
Very good. So is the decision of an administrative character. Very good, because it is not, if it is not of an administrative character in the sense that it is a judicial decision or a legislative decision, then it is not appropriate for judicial review. Very good. What else? So there's that aspect of legal standing. Yes? So does the applicant, such as Manson, have legal standing? What else? Okay, I see an answer here from Emma, under enactment. Can somebody explain the relevance of the concept of under enactment? So in other words, was the decision made on the basis of an enactment? And my related question is, so what if a decision is not made on the basis of an enactment? Does it mean that it is not appropriate for judicial review?
No, it doesn't mean that at all. There are decisions that can be made without an actual enactment, and considering budgetary decisions and stuff like that.
Okay, so perhaps the more specific question there, Peter, is that what if there is a decision that is not made on the basis of an enactment, on the basis, for example, of a statute passed by the Commonwealth Parliament? Does it mean that that administrative decision is can no longer be the subject of judicial review? In other words, is it necessary before an administrative decision can be the subject of judicial review that administrative decision must have been made on the basis of an enactment or under an enactment?
No, it doesn't. It can be subject to judicial review, even
if the decision was not made under enactment. So
that's right.
That's the correct rule there. So, who was that?
Sorry, can't it be a decision based on a prerogative power, so as long as it doesn't affect the rights or contrary to the Section 75 of the Constitution?
Go on, Jesse. So, what's the critical point there?
That's as far as I got. Sorry.
Okay, so what is the relevance of a decision being made under an enactment in terms of judicial review? Because this is an important point that I was raising. It is important. But when is it relevant and when is it important? The idea that the administrative decision was made under an enactment.
Does it change the grounds for review? So if it's under an enactment, then are there grounds specified in like the ADJR Act? And if it's a common law, I've lost the word, but that's what I'm trying to get at. I hope that makes sense. Okay, common law grounds. Sorry, there we go.
Okay, very good. So the idea that an administrative decision was made under an enactment is only crucial if your purpose for, if your legal basis for applying for judicial review is the Administrative Decisions Judicial Review Act of 1977 Commonwealth. Okay, but it does not mean that if a decision was made not under an enactment, but say on the basis of broader executive powers or on the basis of prerogative powers, it does not mean that the administrative decision can no longer be the subject of judicial review. It can still be, except that if a decision is made, if an administrative decision is made under an enactment, you have the benefit of being able to seek recourse under the ADJR Act, which one, provides more specific and broader grounds for judicial review as compared to Section 75(5) of the Australian Commonwealth Constitution, or if it's on the basis of Section 39B of the Judiciary Act of 1903 Commonwealth, which is very similar to Section 75(5) of the Commonwealth Constitution. Or if you had sought judicial review on the basis of common law principles. So the beauty of relying on the ADJR Act, because the ADJR Act in a sense codifies, although not exclusively, because it still sits side by side with the Constitution and with common law principles in Section 39B of the Commonwealth of the Judiciary Act of 1903. But the beauty of relying on the ADJR Act of 1977 is that the grounds for judicial review are more specific and broader, and two, the remedies under the ADJR Act are also broader and more extensive than they would be if somebody were to rely, for example, on Section 39B of the Judiciary Act of 1903 or Section 75(5) of the Commonwealth Constitution. Okay, I'm just going to have to move this quickly. What else are we missing here? So there has to be a ground, right? Ground for judicial review. And then remedy. Okay, so as far as we're concerned, the decision is the decision of an administrative character, is it? Yes or no? It has to be, I think. It's made by the Minister of Health.
Well, no on the facts.
Ah, okay, no on the facts. Mm-hmm. Okay, Jess, you wanna explain that?
Do you expect us to make assumptions?
You could. Go ahead. Go ahead. Yes?
No, I got nothing.
Okay, let me just clarify a key point here. There is actually a shorthand. There's a simple way by which the courts try to determine whether a decision is an administrative character or not. And it is simply by asking the question of whether or not the decision is a legislative decision, a judicial decision, or an administrative decision. Okay, so if it is not a judicial decision and it is not a legislative decision, then by necessity, it must be an administrative decision. Okay, so if you go by that reasoning, this cannot be a judicial decision because it is not done by the courts, correct? Is it a legislative decision? Typically, when you speak of a legislative decision, either it is because a law has been passed, and that reflects the decision of the Commonwealth Parliament, or if you go by the cases such as Roche Pharmaceuticals, it would be a legislative decision when its effect is actually broader. It cuts across the entire community. Now, for our purposes, we will just, so Jess was actually correct in that sense that it will be tricky whether or not this is actually a legislative decision, because in the sense that it applies to all, and whether or not it is one of administrative character. But we're not going to go there for now because it's not really important for the purpose of trying to answer this. But you're correct, Jess, in asking that question, because this might be a legislative decision on the basis of the fact, following Roche Pharmaceuticals, that it has a broad application. So, but for our purposes, let's just assume that this seems to be an administrative decision of an administrative character, mainly because this was a decision made by the Minister of Health. let's go to that question of justiciability. What are your thoughts about justiciability here? What exactly is justiciability?
Something that the court. Sorry, Peter. I saw you took. You go.
It's able to be an issue that can be decided in the court,
okay,
or can be brought before the court.
Okay, and when can it be said that a matter can be brought before a court? So in other words, when is it justiciable? And when is it not justiciable, in other words? Monique, did you want to? Thank you, Peter. Monique, did you want to?
I was going to say similar to what Peter said, so I'll try at the next bit. So an example of a non-justiciable matter would be something that's best left to Parliament under the principles of responsible and representative government.
Very good.
Where you know, the courts are hesitant to intervene because it's not really their role to tell Parliament how to do their job.
Very good. Thank you, Monique. So there are actually at least three conceptions of justiciability. The first conception of justiciability is that the matter or the legal, even if it involved a legal question, it is actually one that is best left to the elected members of Parliament under the principle of representative democracy. So when it concerns issues about national policy or certain policy questions about how resources should be divided or allocated across society, or when it involves political questions, when it involves national security, then these are known as non-justiciable questions because they're best left to the elected members of the government, such as the Commonwealth Parliament. And the judiciary, therefore, as appointed members, would rather defer to the elected members of the government to make these types of policy decisions because they're essentially political decisions. The second aspect of that is that it may, because these are political decisions, in a sense, it may be that any decision does not actually rest on legal standards, but political standards. And courts are not really suited to make decisions on the basis of policy decisions or politics. So, because remember, the duty or the task of courts is actually to examine the legality of decisions, and it's not for them to examine, the correctness or whether or not it's preferable to make a decision or that, unless it's a legal standard. There is a third element concerning justiciability, and that relates to the issue of legal standing, in the sense that it is possible to argue that when a decision is made, for example, by whether the executive or the Commonwealth Parliament, it is a decision that applies to all, so that it's difficult for a single individual to say that he actually has legal standing. And related to the second point that I said about political decisions, the other one is really the issue about legal standards. So as I said, as far as judges are concerned or the courts are concerned, they only make determinations on the basis of what are known as legal standards. So that's the issue of justiciability. So on the issue of justiciability, what would you advise, what's his name? Red Manson. Is this a justiciable question?
I don't think it is, because I think it's more a political question.
Okay, very good. So we can agree that this involves a political question that is best left to the elected members of government to decide. It is a political question because it involves a policy decision. So as far as you acting as a solicitor is concerned, there is a problem about non-justiciability. Okay. Does the applicant Manson have legal standing?
He's not directly involved, so I don't see that he has any legal standing either.
No legal standing. So that's the second problem that Red Manson is facing. grounds for judicial review, and we're focusing this time on the decision being unauthorized. Is the decision authorized or not? Assuming that Red Manson had legal standing, assuming that this were a justiciable matter, so we're making assumptions, assuming. Because remember, when you have a final assessment, you need to go through all of these, unless I say in the assessment task that focus on this particular issue. So, assuming that Red Manson had legal standing, we're just assuming, because we want to focus on the question of grounds for judicial review. Assuming that the question was justiciable, would there have been a ground for judicial review on the basis that the decision is unauthorized? Is the decision authorized or not?
Sorry.
Go ahead.
I would say that it is one of those decisions that falls in the realm of actually doesn't require any specific statutory authorization, and it's just perhaps impliedly authorized.
So is it authorized or not?
Well, I would have said yes, that it's just, you know, part of the role and the powers of a minister to do such things, that he doesn't actually need a statute or anything like that to say that he can make those decisions.
Okay, so just to clarify, is it necessary for an executive decision maker, before he or she can make a decision, to have statutory authority? In other words, authority coming from the Commonwealth Parliament on the basis of a statute or law?
No.
No, the answer is no. That's correct. So it is not necessary for an executive decision maker to always rely on a statutory grant. Section 61 of the Commonwealth Constitution provides the executive with executive powers. So in other words, the executive can rely on that as a source of his powers. You can also have as a source of authority, as Kathleen Smith pointed out here, inherent or prerogative powers. So these inherent or prerogative powers are powers which courts recognize inhere in the executive as the executive, because if you do not, if the courts do not assume that the executive certain executive powers, then how can it function if it always has to rely on statutory authority? But this brings us to that related point. Do you remember the case of Entick versus Carrington? Okay, which is actually one of the discussion questions there, but it kind of, so Entick versus Carrington talked about the common law principle of legality. How does the principle of legality relate to that idea that you need legal authority? Especially, in particular, you need statutory authority for certain actions by the executive. Can somebody try to explain that?
I would just contrast the Entick versus Carrington principle of legality point to this decision's not really infringing on the rights and freedoms of any individuals.
Very good.
And I can't remember the wording of Entick versus Carrington, but I think it had something to do along those lines, and where a decision is going to infringe on the rights and freedoms of an individual, that there needs to be a positive law. Is that right?
That's correct. So if we follow the principle of legality, the requirement, which is part of the rule of law, the requirement is that for the executive to take action that infringes or interferes or impairs the rights or interests of citizens, then there has to be a positive law. So it is only in those instances when the actions of the executive interfere or impair the rights or interests or freedoms of citizens that the executive must be able to rely on positive law. In other words, on statute passed by the Commonwealth Parliament. In the absence of that statutory authority, the actions of the executive would be invalid, illegal, unlawful, and ultra vires, because the courts in the case of Entick versus Carrington were clear that while there might be prerogative powers, those prerogative powers cannot be exercised if they infringe or impair the rights or interests or freedoms of citizens. So where there is no right or interest or freedom that is impaired by or interfered with by a decision of the executive, then you don't need a positive law. When you speak of positive law, we're talking about a statute passed by the Commonwealth Parliament. So in this particular case, we can see that, so in this case, is there an impairment or an interference with the rights, interests, or freedoms of Red Manson? Peter is shaking her head. Why not, Peter?
Well, he's not being restricted in any way. His liberty is not being restricted. He's not being imprisoned. His dignity might be hurt, but that's about it.
Right, and he cannot assert that he has a right to specific funding. There's no such thing. Okay, very good. So to answer the question, if Red Manson comes to me as a solicitor, what would I advise him? I would advise him that he shouldn't be applying for judicial review for 3 key reasons. One, the matter is likely to involve a non-justiciable question because it involves a political question. So this is a matter that is not ripe for determination by the courts. So one, it's non-justiciable. 2, Red Manson has no legal standing because he has no specific right apart from the rights as part of a broader community that are impacted by the decision of the Minister of Health. So he has no legal standing, and legal standing is crucial to an application for judicial review. And that is part of the question about, matter. There must be an actual controversy involving the rights or freedoms or interests of a person. And third, there is no ground for judicial review because the possible ground for judicial review would have been that the decision is unauthorized. But in this particular case, there is no right or interest or freedom of Red Manson that has been violated, interfered with, or impaired by the decision of the administrative decision maker. The decision made by the Minister of Health is authorized on the basis of broader executive powers, either on the basis of the Constitution or on the basis of what are known as inherent powers of the executive, which exist outside of any statutory grant by the Commonwealth Parliament. Questions? We kind of took too long there. Hang on. We're just going to go through this quickly. Is there an issue about us extending beyond 8 o'clock? Would that be all right? Because we still have 3 questions to go. We're kind of slow there. Is that all right? I mean, if you need to drop out at some point, that will be fine. Okay then. Can somebody read question 3 for us, please? And as I said, my limitation really is that I can't see everyone else on the screen. I've only got 5 students here that I can see on my screen. So if you want to raise your hand, you either need to turn on the mic, or if you raise your hand, I'm not even going to be able to see it. So you probably have to turn on your mic if you wanted to say something, because that's a limitation of Zoom, or you type a message in the chat box that you'd like to say something, or otherwise, just start saying something and turn on the mic. Can I have somebody volunteer to read question 3 for us, please?
Sure. Okay. Claiming broad powers under the Australian National Security Act Commonwealth, the Australian Security Intelligence Organisation, ASIO, Director General of Security, ordered the arrest and detention for a period of 90 days of Jameson Ibrahim, an Australian citizen who is alleged to have recently committed atrocities in Syria. Ibrahim's solicitor filed an application with the Federal Court of Australia for judicial review of the legality of his continuing detention. The ASIO Director General of Security asserts that the detention is legal since it is authorised by the Australian National Security Act Commonwealth, which provides that the ASIO Director General of Security may cause the arrest and detention for a period not exceeding 120 days of any person who he considers on proper evaluation to be a threat to national security. Advice on the validity of the ASIO Director General of Security's
argument. Okay, very good. What is the legal issue here?
Has Abraham been treated fairly?
Okay. And then I'll provide my comments in a short while. So from PETA, the legal issue, we're trying to identify the legal issue here. We're doing this because we're trying to prepare ourselves for the final assessment, which involves really identifying the legal issue. So from PETA, there's a question of fairness. And then from Kathleen, there is no clear statute. So is there a statute authorizing the detention? Okay.
What about whether the Director General had authority to make that decision?
Okay, so does the DG have authority to make the decision? Okay, very good.
Did he undertake a proper evaluation?
Okay, very good. Okay. Okay. Anything else? Let's just go through this, you know, these points one at a time. Fairness. Okay. Is that a ground that can invalidate an administrative decision of its own? And Monique was reaching the point, is it a very broad concept? So is there a freestanding concept of fairness, so that if a decision is not fair, then the decision has to be invalid? Okay, probably not. As Monique said, okay, I thought I heard something there. Okay, very subjective. Okay. So Monique was saying that fairness is too broad a concept and too subjective. And we will try to get back to the notion of subjectivity in a short while, because that is related to the quiz. Statutory authority for the detention. Then there's a notion of natural justice. Okay, let's talk about natural justice before we talk about statutory authority. What is the rule about natural justice? What is the rule of natural justice? Can somebody remind us? Okay, I'll just go straight to it. The rule about natural, so the failure of a decision maker to accord natural justice to an applicant or to an individual is a ground for judicial review, not only under the ADGR Act, but under common law principles. So there's a requirement that an individual should be accorded natural justice. However, the other clear rule is that because the principle of natural justice is of common law origin, in other words, it is a principle that is fashioned by the courts, it can be displaced by express formulation of the Commonwealth Parliament. So the Commonwealth Parliament, by law or by statute, can expressly say that the principles of natural justice will not apply. And so if the Commonwealth Parliament says that the common law principles of natural justice will not apply, then there is no right to natural justice that can be spoken of, because the right to natural justice is a common law right that can be displaced by statute. Okay, so in this particular case, it can be said that there is no right to natural justice because the Australian National Security Act itself enables or authorizes the Director General of Security to order the arrest and detention of a person for a period of 90 days. Okay, as pointed out by Kathleen, though, the statute that seeks to displace the right of natural justice must make that expression in clear and equivocal language. Very good. So probably not natural justice here. How about the statutory authority for the detention? What can you say about that? Okay, so I'll be more specific this time because I'm trying to not be too slow this time. I'm aware 7:50. Can the Director General say that his actions are actually valid because he is relying on the Australian National Security Act, which authorizes him to act and decide in that particular manner? So there seems, hang on, what's that? Okay, so in other words, the ACO Director General is saying that he is authorized by the Act, and because he is authorized by the Act, his actions cannot be invalid. So let's look at that as a legal issue. Is that correct? So would it be correct that the executive can do anything and everything for as long as he is authorized by a statute? Let's begin with that first point. Kathleen says no. Leonie says no. Why is that?
Does it have anything to do with them staying within the statutory limits and not exceeding their powers?
Okay.
What's been expressly listed in that statute?
Very good. So that's a different point. We're going to go there. That's the ultra vires point that I but you're right. You're right about that, Leonie, because here the Act says he can do it for 120 days in the facts. So he's authorized by the Australian National Security Act, which provides the ASIO Director General can cause the arrest and detention of a person not exceeding 120 days. So it's not ultra vires. The Director General is acting within the boundaries and parameters of the law. So I go back to that question. Can the executive decision maker rely on the statute so that for as long as the executive acts within the bounds of the statute, then necessarily his actions and decisions must be valid? Was my question clear? Was my question clear? Should I repeat the question? So,
yes, please.
Okay, so I'll repeat the question. Can an executive argue that his actions or decisions are valid because they are authorized by a statute? And that's the end of it. So for as long as the executive can actually cite statutory authority, then necessarily the actions of the executive have to be valid. What do you think?
Yes, he can. I think he can.
Okay.
So, I'll say no.
Okay, Jess, did I read your name, pronounce your name correctly, Jess? Is that Jess or Jessie?
Jessie, Jess, whatever you want to call me.
Okay, Jess. Yeah, I mean, the contraction of the name could be Jess. Okay, Jess, what do you think? You said no. Why is that?
Well, I'm just looking at the ADJR Act, and Section 5(1)(e) says that it suggests that decisions can be an improper exercise of power conferred by the enactment in the pursuance of which it is purported to be made.
Okay. Now, that particular provision is likely different because while in that provision, while there is statutory authority for the action or decision, it was an improper exercise of the power. This question relates to whether or not the fact that there is a law that authorizes or a statute authorizing the action of the executive, does it mean that the action will always be valid? Will always therefore be valid. So I will make this.
Sorry.
Go ahead. Go ahead, Amanda.
I was going to just say that as long as he's certain that Jamison Ibrahim has committed the atrocities, then he should be able to carry out what the legislation says, isn't it? What the Act says.
I'll give further examples. Thank you, Amanda. I'll give you further examples. What if the Commonwealth Parliament passes a law authorizing the ASIO Director General or the Australian Federal Police to shoot people on sight if that person is suspected of committing a crime, or authorizes torture, or authorizes waterboarding and so on?
That interferes with human rights.
Huh?
Well, it interferes with human rights, so there would need to be some type of positive legislation that allowed them to do that.
Okay, let's assume that there is in fact a positive law. So it is the Commonwealth Parliament authorizing the use of torture, the use of, shoot to kill on sight, that type of thing. Would it mean, therefore, that the actions of the executive would therefore be valid because they can rely on a statute which grants them express authority to do so? That is the question.
Yes, but because of our separation of powers and all the checks and balances, it would never actually go through because another level of authority would change it because they would see the unfairness in it.
Okay, very good. I look the answers here of Leone, and the answer there is that there are limits to what the executive can do, even if it is authorized by the Commonwealth Parliament. So the particular case is A versus Hayden, number 2. The rule is that even the Commonwealth Parliament is restricted in its exercise of its powers by the Australian Commonwealth Constitution. So there are certain things it cannot do. And one of the things that the Australian Commonwealth Parliament cannot do, following the case of A versus Hayden number 2, for example, is to insulate the executive from being liable for criminal acts. There are limits to what the Commonwealth Parliament can do, given the fact that we are a representative democracy. So it is legally doubtful that the Commonwealth Parliament can pass a law that would authorize the use of torture. Okay, so in other words, whilst in general, for as long as the actions of the executive are grounded on statutory authority, a statutory authority can actually be contrary to the Constitution. And if it is, it then invalidates even the actions of the executive. So in relation to this particular question, in terms of the actions of the Director General of Security, number 1, it can be said that the actions of the Director General interfere with or infringe on the freedoms and liberty of a citizen, such as Ibrahim. And what then is required, following the case of R versus Home Secretary, as well as the case of Hicks versus Roddock or Coco versus the Queen, is that there has to be clear legislative authority for any infringement of the rights and freedoms of citizens. Now, that's one. But secondly, even assuming that there was clear statutory authority for the infringement of a person's rights and freedoms, there are constraints on the powers of the Commonwealth Parliament. Because of the Constitution and because of the principles of constitutionalism and representative democracy. And one of those would be that in our legal system, it would be against the rule of law for the Commonwealth Parliament to just permit the detention of a person for a long period of time. The particular case there would be Alcatab versus Goodwin, because when, for example, the law passed by the Commonwealth Parliament authorizes a long detention, that would then amount to a punishment. And the courts have said in the case of Alcatab versus Goodwin that in that case, that is no longer preventive detention, but that would amount to a punishment. And if the detention amounts to a punishment, only the courts have the power to do that on the basis of the separation of powers. So I would advise that the actions of the ASIO Director General are likely to be invalid, and that therefore the lawyer of Ibrahim should file an application for judicial review? Questions? Okay. Let's proceed to discussion question 4. And I think it is this one that is, I'm flagging it now. It is this question that is quite similar to the quiz. So we're now 8 o'clock. It's now 8 o'clock. For those who want to drop out because you need to do something else, feel free to do so. I'm just going to spend a few more minutes covering the last 2 questions, just for us to have a better sense of the legal principles here relating to week 5. Can I ask somebody to read question 4 for us?
I'll read it, Manjo.
Thank you, Leonie.
Okay. Gail Ashgrove decided to pursue a Master's in Political Studies at an Australian university and applied for a scholarship under the Research Development Scholarship Grant Act, administered by the Australian Department of Education. Gail was confident that she would get a scholarship because she graduated with first-class honours and was an active student leader when she did her bachelor's degree. Gail was thus very disappointed to receive a rejection letter informing her that her application had been unsuccessful because of her prior involvement in a student protest against the Chinese Premier in Canberra in 2015. The Act provides that the Minister of Education has the power to impose additional selection criteria to the scholarship selection process as he sees fit. Gail has come to you for advice. As a solicitor, advise Gail what her legal options are.
Okay. I will identify the legal issue here just to cut to the chase because of time constraints. The legal issue really here is whether or not because the Act provides that the Minister of Education has the power to impose additional selection criteria to the scholarship selection process as he sees fit. That standard about him seeing it fit, is that a subjective standard or is it an objective standard which can actually be evaluated by the courts? Because remember, if it involves a subjective judgment, and will probably involve the use of discretion, policy, and so on, that becomes a question relating to merits, which courts refrain from reviewing out of deference for decisions made by the executive. So is this that portion about him seeing fit, does that involve a subjective standard? So in other words, if the Minister for Education, for example, were to require that that an applicant must be one who is healthy, or an applicant must be one who have with red hair, for example, because it says as he sees fit. Does it make it therefore beyond the power of judicial review to examine? So the idea of the standard of as he sees fit, can that be the subject of judicial review? Monique says no, then she says yes.
Oh, I just felt like I answered 2 different questions. Sorry.
Okay, you're probably right. I mean, have, Monique, you want to have a go?
Okay, so I'm completely lost now. Can you repeat one of the questions and it might help me?
So the basic question is, can the decision of the Minister of Education be the subject of an application for judicial review? And if so, why? And if so, why not? And if not, why not?
Okay, I think yes, it can, because you still need to consider the reasonableness of his additional criteria or how he applied her application to that additional criteria. That would be my thoughts.
Very good. So that's the correct answer, following the case of George versus Rocket, McKinnon versus Secretary Department Treasury, and Goldie versus Commonwealth. So that even when an executive, very good, Monique, so even when an executive is given the power to make a decision as he sees fit, that is not that does not give him unfettered power to make a decision however he likes. It still must be reasonable. Because otherwise, if it is unreasonable, it violates, the Westbury unreasonableness principle that we know, or that we talked of earlier, or it is unreasonable following the ADJR Act. So it needs to be reasonable. And because there is a requirement of reasonableness in the exercise of decision making, that can then be the subject of judicial review, and it involves an objective standard. So that whether or not the exercise of decision, whether or not the decision was reasonable, can actually be the subject of judicial review, and it involves objective standards as far as the courts are concerned. So in this particular case, why might it be said that the decision is unreasonable, even if the law actually provides that the Minister of Education can impose additional selection criteria as he sees fit? Okay, from Kathleen, she was not given an opportunity to respond to the new criteria. Okay, does she actually have a right to be able to give a response? What is the bigger question there? What might make the decision unreasonable? Okay, from Kathleen, National Justice, Procedural Fairness. What else? Why would it be unreasonable?
Is it a relevant consideration or not?
Go on.
So my thoughts are that it could be unreasonable because it could be a matter that's irrelevant. Like, I'm not saying that her involvement in the protest was or was not relevant, but if he can just make up reasons, then, it really has to be a relevant reason. Otherwise, then it's not reasonable.
That's right. So that's the correct answer there. It's probably unreasonable to say, to have to require a person not joining a student protest. After all, it is an implied right in a democracy that there is freedom of political communication. So you cannot just casually impair that freedom of communication. So it would be unreasonable, therefore, to come up with a requirement that one must not exercise one's right to political communication. That becomes unreasonable. Now, the issue about relevant consideration is actually a different limb for the purpose of judicial review. And we're going to discuss that at some point, although it's related to the issue about reasonableness. But on this particular problem, the basic question is that the imposition of a selection criteria requiring an applicant not to have been involved in a political protest is likely to be unreasonable because it involves a curtailment of the rights of a person to freedom of political communication, which is an implied right under the Constitution. But even if it were not, it's like, how can that be reasonable? How can that be justified? Why shouldn't a person be? It's like saying a person shouldn't be allowed to enjoy a party or go to a cafe or something. So the crucial legal principle there, however, is that the issue of reasonableness can be subject to judicial review. And even if it might be said to be subjective because it says, as he sees fit, there is actually an objective standard that can be used to test the reasonableness of any decisions made by an executive. So as a solicitor, you should advise Gail to apply for judicial review because the decision of the minister in imposing another selection criteria that would disqualify a person who's involved in a student protest is likely to be unreasonable. And the case for that would be George versus Rocket, and the cases of McKinnon versus Secretary You're part of the Treasury as well as Goldie versus Commonwealth. Questions? Reasonable proportionality test. Yes, I don't want to get into that because there's the question that's good, Amanda, because if we go by the cases, the question about proportionality in terms of the purpose, and then just the question of having a nexus that it can be done. So I'm not going to go into that because we don't have the time. But you're correct in citing that. So I leave it to the rest of the class to try to get to the textbook to look at the requirement of whether or not there has to be proportionality. But for our purposes, there is no need to get into that concept for the purpose of discussion. Question 4. Okay, questions so far? None? So finally, we need to do this. Okay. We're just going to have to do this quickly, if that's all right. We still have 15 students, so that should probably be fine. Can I ask somebody to read discussion question 5 for us?
I'll do it if no one else wants to.
Yes.
Phil Banks decided to pursue a Master's in Political Studies at an Australian university and applied for a scholarship under the Research Development Scholarship Grant, RDSG Act, Commonwealth, the Act, administered by the Australian Department of Education. Hang on a second, I'm just going to move everybody's heads out the way. Phil was confident that he would get a scholarship because he graduated with first-class honours. The Act provides that an applicant who graduates with first-class honours shall qualify for the Research Development Scholarship. The Act also provides that the Minister of Education has the power to impose additional selection criteria to the scholarship selection process as he sees fit. The Minister issued the Research Development Scholarship Grant, DSG guidelines, which provides that an applicant, in order to qualify for the Research Development Scholarship, must, in addition to graduating with first-class honours, also demonstrate an involvement in student leadership during his or her university years. Phil was thus very disappointed to receive a rejection letter informing him that his application had been unsuccessful because he could not demonstrate an involvement in student leadership during his university years. Phil has come to you for advice. As a solicitor, advise him what his legal options are.
Okay. Is there a ground for judicial review? Does Phil have a ground for judicial review? Let's just stick it. So we will assume that Phil has legal standing here because it appears that he has a right or legitimate expectation that he should have gotten the scholarship, but he did not. Because notably, the Act says that a person who has first-class honors shall qualify. It is mandatory, correct? And yet the guidelines of the minister said that in addition to graduating with first-class honors, a person, an applicant, must also demonstrate an involvement in student leadership. So in other words, what you can see here is that this is what the law says at its core. If you have a first-class honors, you get it. And yet the minister has the power to impose additional selection criteria, and in doing so, he has added the requirement that the person must also be a student leader. So is there a ground for judicial review?
I don't think so, because the guidelines were the definite guidelines, and obviously he hasn't demonstrated that according to the guidelines that he, even though he's got one part of it there, the minister's added that second extra guidelines, and he knew about them and hasn't sort of demonstrated that he could do, that he had that leadership.
Good point there. So Peter was making a very good point that actually Phil Banks knew in advance, presumably, that the guidelines also required a demonstration in student leadership. So there couldn't have been, a problem about natural justice. But the bigger question really here is that there seems to be a conflict between the statute and the guidelines, because the statute says that a person as first-class honors shall qualify for the scholarship. The minister, however, has imposed an additional criterion. Although that seems to be authorized by the Act as well, because the Minister of Education has the power to impose additional selection criteria. So what now? Leonie says guidelines are not the law. What do we mean by that? Because remember, even under the ADGR Act, the guidelines issued by a minister are considered an enactment. So they are the law. From Faraz, statutes win. Go on, Faraz, if you could explain that for us. You are in the right direction, actually.
Yeah, I mean, from what I gather, I think the statutes, the enactment takes precedence over the minister's guidelines.
That's right. So this is crucial because this question will come up in the final assessment. I'm flagging that already. So the regulations, so as correctly pointed out by Faraz, the regulations are actually the form, or the regulations or the guidelines by the minister are actually what are known as subordinate legislation. They are subordinate to the primary legislation. So in other words, the primary legislation is the one that was passed by the Commonwealth Parliament. That is primary. And there is a subordinate legislation that on the basis of the statute or primary legislation of the Commonwealth Parliament, the minister then has the power to pass guidelines or regulations. The rule, however, is that those regulations or bylaws or guidelines must not be in conflict with the primary legislation. Because in the event there is a conflict between the primary legislation passed by the Commonwealth Parliament and the guidelines issued by the minister, then those guidelines will be invalid because they cannot be inconsistent with the enabling statute. Okay, so that is the basic law. And you should encounter this in the case of Green versus Daniels, because that's what the court said. Justice Kirby said in Green versus Daniels. So that is a basic principle. A subordinate legislation cannot override, cannot displace a statutory enactment. Okay, so here, Phil Banks should have been qualified to the scholarship because he had first-class honors, because that is what the law said, shall qualify. However, the minister's guidelines could have applied to somebody else. So somebody who probably has second-class honors may be required by the minister to be involved in student leadership. In that context, the guidelines are not invalid as a whole. It's only invalid in relation to requiring persons who have graduated with first-class honors to also be able to demonstrate an involvement in student leadership. So if I were the solicitor of Phil, I would advise him to apply for judicial review because the guidelines of the minister are contrary to the enabling statute. And because they're contrary to the enabling statute, therefore, following Green versus Daniels, the guidelines of the minister are invalid. Okay. Questions? And it's probably time for us to end tonight's session. It's 8:20. Questions, comments before we end tonight's session? From Kathleen, does it not just mean that he qualifies to apply? Well, that could be one reading, but if you read what I wrote there, it says shall qualify for the research development scholarship. I didn't say shall qualify to apply. So that could be one way of saying it. But I think I wrote the law more specifically to say that anyone with first-class honors shall qualify. Okay, questions, comments before we go? We're good? Okay then. So thank you very much for joining tonight's session. I hope you learned something. I hope you'll be able to answer the quiz correctly. And I look forward to seeing you again next week. Bye. Good night.